Welcome back to another explainer. I'm really glad you're joining us today. We are going to be doing a deep dive architectural audit of the complex legal frameworks that are currently blocking human rights justice in Indonesia. If you're a law student, a policymaker, or a human rights advocacy leader trying to map out concrete reform strategies, you are in the exact right place. We're going to methodically tear down the blueprints of the system to see exactly where it breaks down. We'll look closely at the laws, the institutions, and the very real structural hurdles that stand in the way of true accountability.
Here is our roadmap for today's explainer. First, the justice deadlock. Second, domestic friction. Third, the international court illusion. Fourth, the complementarity principle. Fifth, the non-judicial path. And finally, Section 6 will wrap up with a blueprint for advocacy.
Okay, let's kick things off with Section 1, the justice deadlock, looking at constitutional promises versus judicial stagnation.
Now, you might be wondering why we call this a deadlock. Well, there's a massive paradox right at the center of this issue. On paper, specifically in Chapter XA of the 1945 Constitution, the state firmly, undeniably affirms human rights protection. The legal foundation is absolutely there. It's codified in the nation's highest text. Yet, despite that, the actual legal resolution for severe human rights violations remains completely frozen in time. Why? Because the implementation of these grand constitutional promises is paralyzed by deep-seated institutional friction and a genuine lack of absolute political will. The law exists, sure, but the gears of justice simply aren't turning when it comes to prosecuting historical, severe violations. Which leads us perfectly into Section 2, domestic friction, specifically the battle between investigators and prosecutors. So what does this domestic friction actually look like in practice? At its core, we're looking at a heavyweight institutional standoff between two massive state bodies locked in a dissenting interpretation of the law. On one side, you have Komnas HAM. They act as the official investigator for these severe human rights violations. They're the ones on the ground, gathering evidence, interviewing the witnesses, and building the foundation of a case. On the other side, you have the Attorney General, acting as the legal prosecutor and investigator under Law Number 26 of the year 2000. Instead of a smooth, seamless handover from investigation to prosecution, these two bodies are fundamentally at odds over how evidence should be evaluated and what exactly constitutes a trial-ready case. It's like two halves of a bridge that just won't connect. And this specific friction creates what is essentially a debilitating three-step cycle that guarantees stagnation. First, Komnas HAM finishes their meticulous work and submits the investigation files. Then, in step 2, almost like clockwork, the Attorney General rejects these files. The stated reason? Usually a lack of what they call formal material requirements. Basically, they claim the evidence is outdated, incomplete, or just insufficient for a solid conviction. In step 3, the files are returned right back to Komnas HAM. Because the evidentiary standards demanded by the prosecutor often conflict with the sheer investigatory realities of decades-old cases, this cycle just repeats indefinitely. It is a relentless bureaucratic ping-pong match that effectively halts any progression toward an actual courtroom. But wait, it gets even more complicated. The obstacles here aren't just bureaucratic, they are intensely political. For any human rights case that occurred prior to the year 2000, setting up an ad hoc human rights court requires a formal recommendation from the House of Representatives, the DPRI, before it can be officially established by presidential decree. Think about what that actually means for a second. Justice suddenly relies entirely on parliamentary power dynamics, political lobbying, and consensus, rather than on the material evidence of a crime. It effectively acts as a political permission slip for a courtroom, transforming the pursuit of justice into a highly politicized commodity and completely undermining the independence of the judicial process.
With the domestic system so jammed up, let's move to Section 3, the international court illusion, and examine why the ICC cannot easily intervene.
A really common question people ask is, hey, if the local courts are stuck, why can't the International Criminal Court just swoop in and act as a first responder to this impunity? It's a widely held assumption that international law provides a quick bypass to broken national systems. It sounds great in theory, but the reality is very different. Extraditing domestic human rights cases to the international level faces extremely strict, nearly insurmountable jurisdictional limitations. The ICC isn't some global police force with unlimited reach. They operate within a very rigid, highly specific legal framework. The legal mechanics of the ICC are based entirely on the 1998 Rome Statute. Because Indonesia is currently a non-state party, meaning they have never formally ratified this international treaty, the ICC faces immediate, hardline accession barriers. In international legal jargon, these are rashani loci and rashane personae. In everyday language, that just means location and people. Because of this non-state party status, the ICC holds absolutely no automatic authority over crimes committed on Indonesian territory and no automatic authority over Indonesian citizens. Their hands are legally tied by the very treaty that created them. Now, there is one theoretical loophole to this barrier. Article 13b of the Rome Statute allows the United Nations Security Council to refer a non-party state to the ICC for investigation. But let's look at the harsh geopolitical reality of how that actually plays out. A UN Security Council referral requires navigating incredibly complex global alliances and, most importantly, avoiding the veto power held by permanent member states. Practically speaking, securing such a referral for Indonesia without triggering a geopolitical veto from an allied nation is considered nearly impossible. The political capital required is simply too vast.
This brings us right to Section 4, defining the complementarity principle, which acts as the ultimate safety net.
To truly understand international jurisdiction, we have to look at Article 17 of the Rome Statute, the complementarity principle. This is a fundamental legal doctrine. International law treats the ICC as an ultimate safety net, a true court of last resort. It is absolutely not designed to be a replacement or a substitute for domestic courts. It only steps in under very specific, catastrophic failures of a national legal system, specifically when that system cannot or will not do the job itself.
So what does that actually mean? There are really only two conditions that can trigger ICC involvement despite this principle of complementarity. A state must be proven either completely unwilling or fundamentally unable. Let's break those down because they are distinct. Unwilling means the state conducts mock trials, fake, theatrical proceedings designed purely to shield suspected perpetrators from genuine justice, creating this legal illusion of accountability. Unable, on the other hand, means there is a total, physical, systemic collapse of the national judicial structure. Think of a nation in the middle of a massive civil war where courthouses are literally destroyed, judges are displaced, and holding a trial is physically impossible. And here is the massive catch for human rights advocates looking at Indonesia. The international community officially classifies Indonesia's judicial system as functioning or able. The courthouses are open, judges are sitting, and regular laws are being applied every single day. Because of this baseline functionality, advocacy leaders face an incredibly steep burden of proof. To trigger international jurisdiction, you'd need incredibly high-precision evidence under strict international standards to demonstrate that the state is absolutely unwilling to prosecute these specific historical crimes. And trust me, that is an incredibly high bar to clear. Given that reality, we pivot to Section 5, Jokowi's non-judicial alternative, and the victim-oriented policy breakthroughs we've seen recently.
Because of this absolute judicial gridlock we've been auditing, we really have to look objectively at the non-judicial alternatives the government has implemented in recent years. If we compare the two paths side by side, the fundamental differences are stark. On the traditional judicial track, governed by Law No. 26 of 2000, the core focus is retributive, punishing the perpetrators. But as we've discussed, its current status is totally stagnant, bogged down by investigator-prosecutor bottlenecks, carrying the extreme risk of absolute impunity if it fails. Conversely, the newer non-judicial track, based on a 2022 presidential decree, focuses entirely on reparations and restoring victim rights. It's progressive, it's moving, but it carries its own major risk, being viewed by the public as a justice barter, where you're effectively trading away criminal accountability for financial or social compensation.
We definitely can't ignore the tangible progressive achievements of this non-judicial track, though. Through this mechanism, the state has factually stepped forward to officially end its historical denial. It openly acknowledged 12 severe past human rights violations, which is a massive departure from decades of silence. Beyond that, it is actively providing existential reparations. We're talking about restoring immigration rights for political exiles who couldn't return home, granting priority health care, and rehabilitating state-seized assets for victims. That's a huge deal for folks who have been waiting most of their lives for any form of recognition or relief from the state.
But, and this is absolutely crucial, we have to look at the United Nations Orange Lucher principles on transitional justice. They draw a hard, non-negotiable line here. Non-judicial reparations must never, ever be used to negating criminal liability. You can't buy your way out of a human rights violation. If you are an advocacy leader navigating this, your strategy has to ensure these processes run strictly parallel. The non-judicial path is amazing for immediate victim relief, but it cannot be allowed to act as a disguised mechanism for long-term impunity. The perpetrators still have to face a courtroom. Which brings us to our final part today, Section 6, a blueprint for future advocacy, synthesizing our reform strategies.
If you're a human rights advocacy leader looking forward, structural restructuring of the legal framework has to be your step one. We have to address the exact root causes we audited earlier. Advocates must push to radically amend Law Number 26 of 2000. Within that amendment, we need a clear, legally binding demarcation of institutional authority to finally stop that endless ping-pong of case files between investigators and prosecutors. Crucially, the law has to permanently strip away political prerequisites, like that parliamentary recommendation requirement for ad hoc courts we talked about. Justice doesn't need a political permission slip. Finally, the system must fully adopt the principle of command responsibility to make sure that the ultimate decision-makers, and not just the foot soldiers, are the ones held accountable.
Another huge piece of the puzzle for this strategic blueprint is establishing a Real Truth and Reconciliation Commission, or KKR. But to build a successful one, we have to look at a past failure. Back in 2004, Indonesia actually passed a KKR law, but the Constitutional Court totally struck it down just 2 years later in 2006. Why? Because the law had a massive, fatal legal flaw. It unconstitutionally required victims to accept amnesty for the perpetrators before those victims could receive the reparations. It essentially alienated victim reparations for the sake of forced forgiveness, which the court rightly ruled was a blatant, unacceptable violation of constitutional rights. So, any future legislation for a Truth and Reconciliation Commission has to learn from that exact mistake. It absolutely demands an entirely independent mandate, totally insulated from political interference. It has to focus purely on victim-centric truth-seeking, relying on actual historical documents and testimonies, and above all, it must firmly reject any prerequisites of amnesty for crimes against humanity. The fundamental right to historical truth and compensation just cannot be held hostage by a demand for systemic impunity.
We've audited the system today. We've seen the institutional friction. We've broken down the illusion of an easy international rescue, and we've weighed the complexities of non-judicial reparations. The architectural flaws blocking human rights justice are incredibly clear, but so are the pathways for reform. So as we look at these systemic blockers and the blueprint we've just laid out, we really have to ask ourselves, are we going to actively restructure our legal foundation to demand real accountability, or are we simply going to allow this cycle of impunity to continue and repeat history? Thank you so much for exploring this with me today on The Explainer. Keep analyzing, keep pushing for clarity, and I'll catch you next time.